My name is Eric Westacott, and I'm an attorney with AEGIS Professional Services. My practice is split in half between entrepreneurial activities for the early stage entrepreneur and then estate planning. And it sounds like they don't go hand in hand, but hopefully we'll talk about some concepts here that do show how those do. In doing preparation for this little chat, I wanted to see how many Americans actually have thought about their estate plans. And so I did a quick piece of research and shows that 64% of Americans have not completed either a simple will or done any kind of estate planning whatsoever, even with the proliferation of available materials online, the likes of LegalZoom, Rocket Lawyer, etc. And the most interesting fact about that is that's down 12%, meaning there are fewer people now doing that than 5 years ago. And even more so, if we look at Generation X, 70% of those folks who are now in the wealth accumulation stage do not have an estate plan or even a simple will either. So what we're talking about here today is something that's immensely important and largely forgotten. So hopefully we're doing this to raise some awareness and also provide some understanding of what needs to be done and how easy it is to do. And we're starting off with sort of just an overview of what traditional estate planning really is. And we're talking about estate planning. What we're talking about are sort of two concepts. The first is how to protect those assets that you have accumulated through your life. And the second is the mechanisms by which we pass those on to the next generation or to select institutions. And so the main mechanisms by which we use to do those things are listed here. We have powers of attorney, healthcare directives, living wills, trusts. And those assets that we're talking about are listed there. And the important thing to discuss here is that these assets that we're talking about as traditional assets are tangible, viable things. We can grab onto them, we can feel them, we can touch them, we can see them, we can visit them. So in direct contrast to that, we have technological progress, which has provided us with digital assets. We've put together sort of a general definition, and I need to stress here in that there is no standard definition, there is no standard understanding across any board whatsoever, whether it be technological, whether it be legislative, whatever, about what a digital asset really is. And as we go through the slideshow here, you'll see where levels of thinking are in relationship to this topic. And I think that's one of the take-home points as well, is that this is such an embryonic field, nobody really knows where it's going yet, and we're plowing new turf. There is no case law in the state of Missouri, none whatsoever. So let's look at our definition here, and I think we can sort of break it down into 4 bits. The first, that it is information in a binary form, simply ones and zeros stored in electronic capacity. Second, we have attached rights to use, and that's really the crux of the matter that we're talking about today. The third part is what's comprised of, and that's media, both images and sounds and text, and it's metadata, and that's something that's often forgotten in this process, and we'll touch on that just very briefly. Okay, so let's talk about some examples of digital assets, and by no means is this an exhaustive list. As a matter of fact, this is a very truncated short list. As we talk today, there are probably 20 to 30 new digital assets being created as we chat. The first one is an online bank account, and that's the Ally Bank symbol. And they offer no brick and mortar banks, so they are an online presence only. Flickster is a database of movies that you can purchase for use and store in the cloud. The third are any sorts of personal photos or videos that you may have collected with any sort of device that's digitized, whether it be a phone, whether it be a camcorder, what have you, that you store electronically. The fourth up there is something I think most everybody's familiar with, and that's Facebook, and what we're capturing there are the various social media web pages that are available. And then the last one are blogs, and that's simply a repository for someone to give their thoughts about a particular topic. Copyright is treated independently because there's already existing law for copyright out there. So if something is copyrighted, we circumvent all of this. Okay, so that's one of the ways around it. And interestingly enough, each of those can house different kinds of value, whether it be a monetary value or whether it be an emotional value. Interesting fact I thought we would throw in just to put some fuel on the fire. McAfee, who's the Intel security company, did a study of all Americans who have an online presence or who use the net. Each of those persons valued their digital estate in excess of $55,000. And that's their entire presence online or their entire presence that's been digitized. That's what they estimated at. So we're talking about considerable wealth. We're not talking about chump change here. Let me give you a couple more examples. Let's say that I am the holder of the domain thenextbigthing.com. And there's a fight over that because somebody wants to name that their business. That can be worth tens of thousands of dollars to me. And there is that distinction. There are those things that are inherently non-monetizable that have no inherent money value. You know, your photos of your wedding or your kids or your grandkids, whatever. You know, that may or may not be valuable to somebody else, but it certainly is to you and your family. Versus the other tangible things that we talked about. Here we talk about why these things are difficult to pass along. We've already touched on the inherently intangible piece. You know, this isn't something you can smell, feel, touch, or go see. These things are ones and zeros stored in some area somewhere. Secondly, they're digitally protected, and oftentimes multiple passwords are necessary through time for multiple platforms. Matter of fact, there's a bank account that I help my grandmother with, and they require a new password every 30 days. So how do you keep track of that if you want to pass that along? And then we run into the problem with the biometric encryption, where someone may have a thumbprint requirement or even a retinal scan requirement. How do you get around that if you want to pass something along? Further complicated by the fact that we store these things in so many different places. You know, if we look at traditional estate planning, we often leave a list where we keep things, whether it be a repository somewhere, a safe deposit box, a home safe, what have you. Well, how do you do that with this kind of asset? It could be stored on CDs that you have in your closet, could be on your laptop, could be on multiple devices. Flash drives that you don't have could be anywhere. And lastly, and something that's a little bit more nuanced is, are we actually talking about the account, or are we talking about the contents of that account? Or the other side of that coin is, are we talking about the content or the right to use that content? And the law hasn't addressed either of them yet. And we'll see examples of both of those here in just a second. Okay, so let's talk about a couple examples. The first one is, obviously we know Mr. Diehard up there. He has been wishing to pass along his iTunes collection to his 4 girls. And he has gone so far as to create some waves in California about how to go about doing this. Evidently, Mr. Willis has several iPods worth of music, and he claims quite valuable. Well, he went to his attorneys and said, okay, I'd like to pass these along to my 4 girls. How do I do that? And the attorney said, well, there's no way to do that because Apple, in signing their user agreement, says that you have access to that only for yourself. Your daughters can have your devices, but they don't have access to those pieces of music. Moreover, you only are able to use those on a certain number of devices as you signed off on. So it's not like you could have a new device and send it on. So he is in quite a bit of a quandary about how to do this. To this date, he still hasn't filed suit. We don't have law on that yet, but I think it may be forthcoming. So Bruce is not able to pass along his music collection to his daughters. Apple still has not responded, nor have they created a mechanism by which to do so. And Apple's the #1 online music seller in the world. You'd think that they'd get wise sometime and figure out how to do this, because the backlash could be rather large. Okay, and our other example is the case of Jake Anderson. Jake was a freshman student at the University of Minnesota, and Jake was coming home one late evening after having attended a gathering and was not seen for a couple of days. Police later found his body and found his cell phone beside him, and the cell phone was crushed such that it wasn't operable. Jake's mom and dad sought to get access to that phone so they could find out what happened to Jake. 2 weeks later, police had closed the case, said that it was an accident, and that there was nothing further they could do. In doing so, they shut down any subpoena power that was available to them to get access to the phone. Dad had phone in his name. Dad had given son phone, but son had signed off on the license agreement, the user license agreement. Well, the Andersons tried to go to Sprint, who was the provider, and said, hey, look, we just want to find out what happened to our son. This is strange circumstances in his passing. We want to see where he was his last few minutes. We want to get the GPS information to find out if this in fact is where he was hurt, and that's the metadata that we talked about before. Metadata being information about information, and that information is inherent in most phones. We want to find out who he talked to, what texts, what emails, what have you. To this day, they've been blocked to do so. The police refuse to open the case, and in doing so, there's no subpoena power, and Sprint can block them directly. Okay? So what solutions are available to this problem that we have? Basically, I have 4 separate entities that have addressed the issue here. The social media companies have tried to use their term of service agreements and their end user licenses to address this a little bit. And then there are new businesses. But Secure Safe, Lives On, and Plan Departure each have a different approach to solving that problem. And then our dear federal government has yet to do anything. They are kind of sitting back and waiting to see what shakes out with this Uniform Law Commission. And the Uniform Law Commission is an independent body that is comprised of practitioners and academicians who try to sit down and write what would be a standard codified procedure for a law to be adopted per state. And so the Uniform Law Commission in 2014 sat down and drafted what they thought should be a useful guide for states to follow in implementing this kind of law. And then in the state of Missouri, we have nothing. We have no case law, we have no statutory guidance, we don't have much of anything except for a strange reference to a Missouri Uniform Fiduciary Digital Assets Act, which we'll talk about here in just a minute. All right, so let's move on and talk about what those social media solutions might be. And when I say solutions here, I'm saying this sort of euphemistically because they really don't want to provide solutions. They want to sell more songs, they want to sell more licenses, they want to do lots of different things. So they try to regulate this on the front end, if you will, through those terms of service agreements and those end user licensing agreements. And often what those say is that an executor or a trustee or someone who would follow in your footsteps is unable, through this language, to have access to your assets. They say, no, we aren't going to allow that. Why is that? Because of these 2 federal laws. The first is the Federal Stored Communications Act. And that is kind of a strange creature in that it arose in the 30s as a reflex to the criminal underworld activity going on and the need for wiretaps. So that's how old this law is. Section 2 of the law goes to talk about computers and was updated in 1986, but nothing has been done since it. And essentially what it does is it says any online account, any electronic account is an absolute privileged account to that account holder. No one else can have access to it any way, shape, or form unless there's authorization given. To have a power of attorney that would encompass the executorship or the trusteeship for these digital assets. The way the law works there is the intent of the person drafting it is going to govern. So if you can, from a practitioner standpoint, draft that POA such that it is as bulletproof as possible to show that intent, you may be able to get around it. But as of yet, we don't know. We just don't know. So then we have the second federal statute, which isn't quite as severe and isn't quite the barrier, but it does provide some guidance to these companies about giving unauthorized access to computers, and it provides for some fines and penalties for companies that do so. So these companies would want to stay within these laws so that they don't get whacked. Furthermore, they want to avoid any conflict of laws principles where we might have issues on which law to apply to a particular lawsuit that comes out. Further compounded by the fact that some of these companies are overseas companies. The social media companies that are out there, and we have 3 examples here, and I think these will be enlightening for us, how they've come about trying to address this issue. And Facebook is probably the most popular social media outlet out there And they've been inundated with requests to pass along these assets with all the photos and whatnot. So most recently, as a matter of fact, in 2014, they created something called a legacy contact, where the account holder can go into the account and actually say, I would like for Joe Smith or whomever to be my legacy contact, and that person then after my passing can have access to this account. Prior to that, the only availability for that account holder to do anything was to either freeze the account or to have it memorialized. And when they say memorialized, that meant that for a static period of time, that account would stay up so that they could post last rites kind of things, where the burial is going to be, that kind of stuff. Bitcoin, which is kind of a strange creature, but because they are on the cutting edge, they have decided to be a little more proactive in that the inherent build of the company was designed to allow passing, in that they actually have a digital vault built into the company where you can store your Bitcoins. That's part of your ability to get online. And second, a part of their wallet process, which divides up piece parts of your account, you can then assign those piece parts to individuals such that if they all got together, they could put the wallet together and have access to your account after you pass. Google, much like Facebook, has just in the last 3 months allowed you to activate what they call a digital heir. And that's on the front side, so as the account holder, I can go in and say, this is my digital heir. Caveat there is that that digital heir only has a 3-month window to download all the content on your Google various sites before it's gone. If someone is proactive as the account holder and does these things, there's likely not a problem. But how many people understand that being proactive is important and to know to do this? Because if you give your password to somebody and they use it, you're breaking those 2 laws. Both you and the person accessing your account are both breaking the law, because you're doing so against that license agreement, and that provider, whether it be Facebook, Bitcoin, Google, could sue you for breaking that license agreement. That'd be a civil penalty. That wouldn't be a criminal penalty because it wouldn't fall underneath that federal statute. That's as to the companies, okay? So a different breaking of the law, but you'd still be in trouble. Some of the new companies that have arisen in this space, well, here are 3 examples. SecureSafe is a Swiss company, and what they've said is, why don't you give me everything that you have digitally, and I'll store it, and I'll give you 1 password. That way, all you have to remember is 1 password, and if you want to pass that along, we'll make it real easy for you. And of course, they do that for a fee. So not much different than, say, a LifeLock or somebody who's been in business previously that may offer the same services. Lives On is actually an app that you can put on your Twitter account that will learn your behavior, and then after you pass on, it will continue to tweet what it thinks you would wanted to have tweeted. I know it's odd, but I thought, wow, who can talk about things like that? So I threw it in here. Very maudlin, but nonetheless, I think illustrative. And then we have probably the most new company is a Scotland-based company called Plan Departure. And what they say is, not only are we going to store all of your digital assets and give you a password, but we're going to allow you to assign beneficiaries to those pieces of digital assets as well. And that's going to be part of our intake process. So a little bit different, but nonetheless trying to solve the problem. So let's talk about that Uniform Law Commission. And they've drafted this proposed law, and its purpose is very simple: to give the fiduciaries the ability to do those things that you're able to do as the account holder. And it talks about those 4 fiduciaries, and you can see those. And those are for whether you have a will, a trust, power of attorney, or what have you. So what the commission has done is tried to find a place within these laws that's not going to upset the laws, but is still going to allow people to have access. And they do so by allowing that fiduciary to actually step in the shoes of the account holder, such that the fiduciary is the account holder, okay? That's how they structure this language, okay? And then for the companies, in order to avoid those federal statutes, they say that if you allow a fiduciary, Mr. Company, to step into the shoes of that account holder, we're not going to be in violation of those terms of service agreements. We're going to exempt that. As of January this year, Delaware adopted this. And in this year, right now, 23 states are contemplating whether to enact this or not. Illinois and Missouri are not two of them. But I would suggest that by end of year, this is going to be commonplace. Okay, a couple of exemptions. This law will not apply to any private email services that an employer or an educational institution would have. So those are specifically exempted, as are those activities of employers and employees who are in the scope of their work and their duties as a business. Those are specifically exempted. So that would still be a fuzzy area. We would know what happens there. Moreover, the law does not address the metadata that's attached to these accounts. That is still kind of hanging out there in the middle of nowhere. So no one would know what happens to that GPS information that's attached to Mr. Anderson's phone. The law is highly definition dependent and nuanced, but if you read it, there are lots of caveats that have to do with the definitions. The law then further excludes those choice of law arguments that we'd had before, and most importantly, it grants immunity to the company or the custodian of those accounts. So if a company said, okay, pursuant to this law, I give you, Mr. Fiduciary Access, I'm no longer liable for anything that happens. So big, big, big safe harbor. Yeah. Missouri law, as I've already said, there isn't any. But I did come across a Missouri bar notion from the fall issue of 2014 that said that we were contemplating this Digital Fiduciary Act ourselves and went so far as to include Missouri language in it. I can't find anything else that speaks to that. I've even spoken to some of the participants in the state government who are on this committee, and they said, I have no idea what you're talking about. So I don't know what to make of this other than to say that it can provide guidance for a practitioner. I think it would be good to follow. For legal purposes, it doesn't hold any sway yet. Okay, so what do we do in the future here? For practical purposes, I think it's best to follow a 5-step plan, and this is for both practitioners and for individuals who have assets. First of all, create an inventory. Find out where that stuff is, what it's all about, and put it down. Spreadsheet's probably the best way to do that. Second, identify the appropriate help you would need to do that, and those people or persons who would help you in this endeavor, whether it be successor trustees, trusted family members, attorneys, financial advisors, whomever you may have to help you do this. Third, provide access. Execute those documents that provide that access, powers of attorney. Make sure the will has a provision for a digital executor. Make sure the trusts have provisions for digital successors. Manifest that intent. Fourthly, think forward as an individual and practitioner to what may happen. In Missouri's case, try to anticipate that federal law or that Uniform Law Commission law will come into Missouri. And then finally, give the appropriate authority. Sign off. Make sure that you as the account holder sign off and say, I give my rights to these people to have access. Lots of us have digital assets we don't even know about. Lots of money and emotional value. Don't know how the heck to pass these things along. And plan ahead as much as you can. That would be my suggestion. And that's it.